Welcome to Fasken's 14th consecutive mining series. My name is Virginia Schweitzer, and I'm part of the Fasken Global Mining Group and co-managing partner of Fasken's Ottawa office. Today, our very interesting webinar is How Will ROFR Provisions Be Interpreted and Enforced by the Courts? It is the fourth in our series of 14 seminars this year. A calendar of all Fasken's PDAC events can be found underneath the video window. Please refer to the slide on your screen for some housekeeping items. Now we'll turn it over to my colleague, Kim Potter, the moderator for today's session, who will introduce today's panel.
Thank you, Virginia. As Virginia mentioned, my name is Kim Potter. I'm a partner in the Litigation and Dispute Resolution Department of Fasken's Toronto office, and I'm joined by two of my partners in the Toronto office, Nancy Eastman and Brian Graves. Nancy has expertise in securities and mining areas of law and works on global transactions, including public company M&A, initial public offerings, corporate finance, drafting and negotiating commercial mining agreements, and royalty and streaming sales and financings. She's been a member of Fasken's Global Mining Group for over 20 years. Brian has been practicing primarily in the mining and metals industry for close to 25 years, and his practice consists mainly of advising on M&A, securities, finance, and commercial matters. He works frequently on complex cross-border mergers, strategic acquisitions, mine financings, and joint venture transactions, and he's considered an authority on metal streamings and royalties. He has written on a variety of topics, taught securities law, as a visiting professor at the University of Western Ontario and at the University of Windsor, and has appeared on the faculty of McMaster's University's Directors College. My practice focuses primarily on business disputes, including breach of contract claims, complex negligence claims, and shareholder disputes. I have industry expertise in mining. I act for mining companies in contractual disputes and before the specialized Ontario Lands Tribunal and appeals from that tribunal, and I hold the Osgood Certificate in Mining Law. Next slide, please. By the end of this presentation, you will know what a ROFR is versus a ROFO and the advantages and disadvantages of each. And you'll learn tips based on how the courts treat the application of these rights in a sale of property that's part of a package, and also how the courts apply the duty of honest performance to creative transactions that discourage the exercise of or avoid a ROFR. And with that, I'm going to turn it over to Nancy.
Thanks, Kim. Okay, ready to jump into the basics of a ROFR and welcome everybody in the virtual audience out there. I wish we could see you, but we're visualizing you all at home or in your office in front of your computer. So we're going to get started and cover at least the basics. So the basic parties involved in a ROFR are, obviously the property owner, the right holder or the ROFR owner, and a third party buyer. Next slide. So first, we're just going to run through, I guess, a basic definition of a ROFR, which I'm sure most of you are probably already familiar with. But in this presentation, we're talking about a ROFR in respect of a property. And by referring to the word property, we really mean any asset that could include real estate, mining claims, other interests, a royalty interest in the mining context, shares of a corporation, joint venture interests, etc. And generally, the way a ROFR work is when the property owner receives an offer from a third party, which it would like to accept, it is obligated to present the same offer to the right holder before it can accept the third party offer and sell the property. So generally, there's a certain time period where the property owner has to give the ROFR holder time to decide whether they want to exercise the ROFR. And that time period is often negotiated in a ROFR provision itself. Obviously the property owner wants as short a time as possible because they don't want to keep a third party purchaser on hold too long or they may lose interest. And at the same time, the ROFR holder typically wants a long period of time, especially if they have to do some due diligence or arrange for financing or get things in order. So those are typically some of the basic provisions that you see in a ROFR to start with. Next slide. So the term ROFO is often used when people are talking about a ROFR or a ROFO, and people throw these terms around not equivalently because they are different concepts. And so for our presentation, we're focusing on ROFRs, but we also wanted to give you a bit of an overview of a ROFO to give you the idea of what the differences are. And a right of first offer, obviously, is a ROFR. And generally, this applies when the property owner decides to sell the property before offering it to a third party. So before they even go out to the market to a third party, they must first give the right holder an opportunity to make an offer. And in this case, if the right holder does not exercise its ROFO, they decide we're not interested, we don't want to even put an offer in the property, or if the property owner does not accept the offer, so the right holder says, oh yes, okay, we are interested in the property, we're going to give you an offer. The property owner can either accept that or not accept it. And if the ROFO is not exercised and the property owner does not accept the offer, the owner is free to go ahead and sell to the third party. In some cases, there are restrictions on the price at which they can sell the property, and that might be a negotiated term in the ROFO provision. As in this case, there may be restrictions on selling it on less favorable terms to the property owner, and in other cases, there may be no restrictions on what you can sell the property at. Next slide. So to think of a little bit of a comparison of, why parties might want a ROFR or why they might want a ROFO, we've put together a couple of slides here to talk about the advantages and disadvantages. The first slide we have is going to be from the perspective of the right holder. So this is the ROFR holder or the ROFO holder. So first, let's look at the advantages that a ROFR holder has in connection with a ROFR. So a ROFR, the right holder has the benefit of knowing that there is an existing offer and the terms might be closer to market. So in this case, the third party has already provided a price to the property owner, which then gets passed on to the ROFR holder. And so they have an idea of what the pricing is, and they can decide based on that price if they want to accept on those terms. So they already have a bit of an advantage to see what the market price is. The other advantage to ROFR holders is that it actually, having a ROFR in place on a property actually deters third-party buyers. So if it's an asset that the ROFR holder is really interested in, it might keep third parties away from buying it because they know it's subject to this ROFR, and that could be advantageous to the ROFR holder. Another context that we often see in the mining industry is when you have two parties to a joint venture and both parties have a ROFR. And this is basically put in place to control your business partner. It gives the ROFR holder a right to control who the other party's interest may be transferred to. So they have a chance, if they don't like this third party buyer, they have a chance to acquire that interest on their own. So that's one advantage. The disadvantages for a ROFR in the perspective of a right holder is that the right holder really has an offer that's presented to them, and they either can accept it or reject it. They can't negotiate the terms of that offer, or that would be seen as a counter offer or a rejection of the initial offer. So you're given the last opportunity to buy it, but you don't really have any wiggle room on the price. So looking at ROFOs instead, we look to see how a right holder may have an advantage holding a ROFO. So in the case of a ROFO, the right holder is free to craft the terms of the offer. So they're no longer stuck, having to take the terms of a ROFR, but they can come up with the terms that they want to present. They also have a right over the asset before anyone else. So it kind of gives them an opportunity, if they think they can come up with a fair offer that the property owner will accept, then it gives them the first opportunity to acquire the property, which can be an advantage. There are also disadvantages, though, to a right holder holding a ROFO, And that is that the onus is on the right holder to know what a competitor offer is. So they're making up the offer. They don't have this third-party offer to compare it to. They're just kind of, having to, figure out what that value is all on their own. So they may be confident in that. They may not be confident in that. The other disadvantage of a ROFO is if it's not accepted, there is risk that the market conditions could change in favor of the property owner. So if the property owner approaches the ROFO holder and says, provide us with an offer, and they decline to do that, there's a chance that the ROFO, the property owner, may go out and they may have a certain period of time which they can market that deal to a third party, and so the market conditions may have changed, and at the time of, compared to the time when the original ROFO holder was trying to determine a price. So those are just some different concepts to think about when you're thinking about the advantages and disadvantages from a right holder. And the next slide, we're going to look at the perspective from a property owner. So the advantages that a property owner may have with a ROFR, so the top left corner, the advantage of a ROFR, the property owner, is it may result in a third-party buyer offering a higher price to discourage the exercise of a ROFR. So that could be an advantage. A disadvantage may be there may be fewer third-party bidders willing to spend the time and money to negotiate a deal to purchase the asset when they know the right holder can step in and buy it. So while they may try to, find third parties that are interested in it, people might shy away if they know it's subject to a ROFR. Now, property owners' advantages with respect to a ROFO, here we have some advantages because it allows the property owner an opportunity to secure a buyer. They know that there's already somebody, who may have an interest in acquiring the property. So they have the opportunity to go and reach out initially without having to market it widely. And again, it's easier to market once the ROFO holder has either declined to put in an offer or their offer has not been accepted. It's easier for the property owner to go out and market the property because they know that it's not subject to a ROFR, and they know that if they can go out to a third party and enter into a deal, that deal can close and it's not going to be conditional upon the exercise of a ROFR. So that provides an advantage. Some disadvantages to the property owner in connection with a ROFR is that it's limited exposure if they need to wait for the royalty holder to decline. So they may have to provide the offer to the ROFO holder and then wait. They may have to wait, whatever period of time. And so that kind of gives them a limited time to go out there and market the property to other potential buyers. Also, the sale process could be delayed while they're waiting for the royalty holder to exercise the property. So it's just a delay problem. And the outcome may be uncertain. If the property owner is in a rush to sell the asset, they may have uncertainty because they have to go to the ROFO holder first, who may decline it, and then they have to go to the market, and they may have no potential purchasers in the market. So that's another slight disadvantage. Okay, next slide. And with that, I'm going to turn it over to Brian.
Thanks, Nancy, and good afternoon, everyone. So now, having defined what we mean by ROFRs and ROFOs and some of their pros and cons, I'd like to step back and just consider a few situations where people, particularly in a mining context, might find these rights useful. And, I'll follow the same protocol that because the intent, if not the mechanics of ROFRs and ROFOs are similar, we'll refer to them generically as ROFRs just for simplicity. So most often, the objective of a ROFR is a defensive one. You may have two or more parties in a long-term relationship. You can think of it as either a shareholders agreement or a joint venture in which they jointly own an asset and there's some cooperation between them that's important to preserving the value of that asset to each of them. And each of them entered into this relationship in reliance of the fact that, and knowledge of who it was getting into business with. And each of them would seek to prevent the substitution of a less desirable partner to the one that they started off with, if their existing partner decided to, for whatever reason, exit the relationship, sell its interest, or allow itself to be acquired. And if that happens, then the ROFR provides a means for the non-selling party to buy out the selling party and to avoid being potentially worse off with a new partner. There's another objective, and I'll call that the sort of defensive character of a ROFR. There's another objective that you see a little bit less often that might be different, in that it's not so much a party trying to protect an interest that it owns, but to acquire something new. And because I don't want to call that an offensive ROFR, I'll call it an acquisitive ROFR instead. And this is a situation where a party might seek, by means of the ROFR in a contract, some preferred right to acquire an asset in the future that its counterparty might subsequently obtain or create for itself. What are some examples of this? We see this a lot in the royalty and the streaming context, where in a particular royalty or stream document, the stream holder or the purchaser might negotiate for itself a royalty or a ROFR to acquire additional royalties or streams created by the seller, either on the same party, the same property, or within an area of interest around it, or even on different properties. So completely different application of a ROFR, but the language of them tends to be similar in both cases. Next slide, please. So since, as I said, defensive ROFRs, as I've characterized them, tend to be a little more common in practice, I'm going to spend some more time on these. So let's consider for a moment a simple example of a joint venture between two parties. The first is a typical junior miner who found a deposit, did some initial exploration on the project and some early development. And the second party is a senior producer, and I'll call them the operator, who was granted a majority interest when the junior chose to partner with the senior once it got past the exploration stage, in order to get assistance in leading the project forward with the benefit of the senior's greater experience and financial resources. It's often the case that the junior partner will at some point want to exit the project at an earlier stage than the operator. Juniors may not be interested in operating the mine over the long term. The business of a junior mining company is more often to identify and develop projects to a certain point and then realize value and then move on. And you've probably seen, a variation of the mining value curve that's shown on this slide. It shows a typical pattern of a project value as it moves through the project life cycle. And so you've got sort of three major phases. You've got an exploration phase at the beginning, in which the project is going from discovery of a brand new deposit through some exploration, through basic development and the identification of the metes and bounds of a project, potentially ending up in a feasibility study. And that's where you see, in the case of a successful find, you'll see a pretty steep upward curve on the value of the project that tends to peak in and around an announcement of feasibility. After that, things don't always go as smoothly in the development of a mine. There may be permitting issues, there may be construction overruns, sometimes financing is difficult to achieve. And so the value of a project, as reflected in the share prices of the parties, may sometimes dip or go a little horizontally for a while. But then, hopefully when it reaches production, there's the possibility of a steady state curve that goes in more of an upward direction. And it's on the left-hand side that we're sort of focusing at this point. Because the greatest relative appreciation and value of a project is early on through, reserve definition up to a feasibility study, at that first big peak would be a pretty opportune time for a junior to exit, realize value, and move on to some other potential project. Next slide, please. If that happens and the junior seeks to sell, the ROFR provides an opportunity for the senior mining company, the operator, to consolidate its interest and acquire 100% interest in the project, instead of, if it didn't do that, potentially having to deal with a new partner, be it a junior or someone else. It also allows the operator to avoid the junior selling off a part of its interest and introducing a new party that might complicate the governance of the joint venture if you were moving from a two-party joint venture to a multi-party joint venture in that circumstance. Majors often seek to avoid that just for simplicity. So on balance, for the operator, the ROFR is a useful right, and it can be seen to create value for it. Next slide, please. On the other hand, if a ROFR is mutual, in theory, it offers the same mechanism for a junior to avoid substitution of another senior producer if an undesired new majority partner should be entering via a potential sale by the majority partner. But a junior might seek to substitute by virtue of a ROFR. It might seek to not be in partnership with a new operator that's brought in because it might see itself again vulnerable to changes in the relationship. The new partner, the new majority partner might have other projects in its pipeline, for example. There may be questions of how it'll prioritize between the projects. It might choose to concentrate on developing others and leave this particular project undeveloped for a period of time. There might be decisions about the scope and size of a project, expansions, cost parameters, all of which could create risk for the junior. So in theory, at least, if the junior had unlimited funds, the ROFR would be a mechanism for it to be able to prevent the exit of the senior from the joint venture. But this does assume, and it's a big assumption, that the junior would have the financial capacity to exercise the ROFR if the major were to propose to sell. The reality is the junior may not have this capacity. It may not be able to fund an exercise of a ROFR. Next slide. What's the effect of this? While there's a ROFR in place, it might actually act as a burden on the junior's interest and either destroy or at least reduce the value to the junior of its interest. The junior's share of the project can sometimes end up trading at an effective discount to the majors, proportionately compared to the major's share of the project. The market sometimes will take the view that the junior is going to be unable to realize full value for its interest in the project. For example, if it were to embark on an auction of its own to sell its junior interest, the market might assume that the major would exercise its ROFR just to do what we said a couple of slides ago. This might have the effect of discouraging some potential bidders from even making offers in the first place. They don't want to be a stalking horse and invest a lot of time in negotiating if there's a high likelihood that they're going to be outbid. It's sometimes difficult to achieve competitive tension in a bid process under these circumstances, and there's also a risk that if the junior seeks to exit, they might be forced to accept a lower offer due to a lack of alternatives for selling their interest. All of these are reasons why, although the ROFR is typically a mutual agreement in situations of this kind, they may not love the ROFR, and they might seek to circumvent it or defeat it if possible. But as we'll see a little bit later in this presentation, it is sometimes possible for a minority partner, despite a lack of funds to exercise the ROFR itself, if it's faced by a proposed exit of its senior partner, to be able to convert the buy-side aspect of a ROFR into an asset and actually market that ROFR. That's a bit of a teaser for a little bit later in this presentation. And with that, I'll turn it back to Kim.
I think we're turning it over to Nancy next.
Got it. Next slide, please. Okay, the next segment of our presentation, we're going to look at some cases in connection with a sale of a property as part of a larger package, and whether or not that triggers the ROFR. So basically, the scenario is you have property X that is subject to a ROFR. Property owner receives an offer to purchase properties A, B, C, and X for an aggregate price. The question is the ROFR triggered? Okay, next slide. Okay, we're going to get into a few cases. So I know we have a lot to say still, so I'll try to go through the facts fairly simply. So in this case, we had a sale of a package of assets. We have Budget, the rental car company that I'm sure you're all quite familiar with. So Budget leased a former service station, I assume a Gulf Canada gas station, and they were operating a car rental service out of the property. So the lease had a ROFR in it that basically gave Budget a right of first refusal if Gulf received a bona fide offer to purchase the lands. So in this case, Gulf sold to Petro-Canada all of its marketing and refining assets west of the Ontario-Quebec border for $311 million in cash and $300 in working capital. There was no purchase price breakdown. There was hundreds of parcels of land that were being sold in this massive asset sale. And the market value of the tiny little property that Budget was leasing was about $700,000, I think, at the time of the court case, but it was actually had a book value, I think, of like $39,000. So next slide, please. Those are the basic facts. So the question of the day is, was Budget's ROFR triggered by Gulf's sale of the property as part of a much larger package? And since we can't do a show of hands, I'm going to let you all think what the answer to this question is as we go to the next slide and find out. Next slide, perfect. Okay, so in this case, so this is an interesting case. We'll listen to this case and we'll park it for a minute. So in this case, the trial judge found that the ROFR was not triggered. So here we had this massive sale of all the assets. Nobody allocated a price to this tiny little one asset. It was just, buried in there with the rest of them. The judge found that the ROFR was not triggered. And some of the reasoning from the case is repeated in the slide here. And the judge basically said that it appeared to him that the transaction was a sale of all the assets and undertakings. It was, in essence, Gulf's business in that territory. Petro-Canada was merely stepping into Gulf's shoes. And he said, and the keywords I think here was that in his view, there was no bona fide offer to purchase, as those words were used by the parties in the ROFR. So let's go to the next slide, because this case was further considered by the Court of Appeal in Ontario. And in Ontario, the majority of the Court of Appeal, so not unanimous, but the majority of the Court of Appeal agreed with the trial judge. And the Court of Appeal stated that the language in the ROFR was clear. And from their point of view, it only applied to a specific offer with an ascribed price for a particular piece of property. And what the court was saying was that Gulf did not have a document in its hand from Petro-Canada that said, we will pay you $700,000 for this one small little asset. So that's an important decision of the Ontario Court of Appeal, just to keep in mind for now. We're going to get into some exceptions later on. But what was interesting to note in that judgment is that the dissenting judge, the judge that did not agree with the majority, basically decided the result was the same. He came to the same result, and that the ROFR was not exercised, but there was other issues in that case, and there were other reasons why he found that. But he made a note to say that he was not in agreement with the majority on the finding of that it wasn't a bona fide offer. And he basically said he had some reservations. Without going into detail, he just sort of made a little comment that he had some reservations on that finding. And so what we're going to see in some other cases that we look at is that budget has actually been distinguished by the courts on the basis that this was a sale on such a large, I guess, relative basis relative to the small property that had the ROFR. But the takeaway from this case is that a sale of that size did not trigger the ROFR for one of the small assets. Next, we're going to look at another case that had so next slide, yeah. Another case that was a kind of a package sale as well, but on a much smaller, different scale and also had some different issues. So this case we're going to look at, Alim Holdings. Basically, the vendors owned two properties. So two adjacent properties was owned by the same person. And that person, the vendor, wanted to sell both properties. And each property was subject to a ROFR in favor of different parties. So one of the ROFR holders was White Spot. The other ROFR holder was CIRP. So the vendors entered into an agreement with a potential third-party purchaser for the sale of both the properties, but they only had an aggregate price of $10 million for both properties. They didn't break it down between the two properties. And that agreement between the vendor and the purchaser was obviously subject to the ROFRs not being exercised. So the vendor went out to the two ROFR holders and said, do you want to exercise your ROFR? The one holder, CIRP, declined to exercise its ROFR. So that was easy, dealt with. White Spot came back and they gave notice that they wanted to exercise their ROFR, and they elected to purchase both the properties. So in this case, when White Spot gave notice to exercise its ROFR, that basically voided the original agreement of purchase and sale on its own terms between the vendor and the purchaser. So the vendor, recognizing that, and they were free to make a deal with White Spot, they basically said, okay, they didn't object to them making an offer or election to purchase both the properties. And the property said, sure, okay, you can buy both properties for $10 million. So before White Spot and the vendors were able to close their deal, the purchaser sued the vendors, claiming that White Spot waived its ROFR or failed to exercise it properly. So they were basically saying, they purported to exercise their ROFR for both properties, and they didn't have a ROFR over both properties. So if we flip to the next slide, we're going to look at the issues that were considered in the case with this one. So the first question was White Spot's ROFR triggered when the vendors offered to sell the property as part of a package? And if we look at budget, that one said no. But here's a different fact situation. Second issue, if so, was White Spot entitled to an offer to purchase the entire package? And three, if not, did White Spot waive or void its ROFR when it purported to elect to purchase the entire package? So those are the issues. So let's jump to the next slide and we'll see what the court said. So in this case, the trial judge held that the original purchase and sale agreement did trigger the ROFR. So this package sale did trigger the ROFR. And then it also decided that White Spot was entitled to a segregated price for the parcels subject to the ROFR. So even though the vendor went to the ROFR holder with this $10 million price for both properties, White Spot should have or could have asked for a segregated price, even though they didn't actually do it. But that's just another right for you to remember that you always have the right to ask for a segregated price. The trial judge also found that the election to exercise the ROFR voided the purchase and sale agreement by its own terms. So even by providing notice that they wanted to exercise a ROFR, even though it wasn't clear what they were exercising it over or over which property or what the price was, that actually voided the conditions, that actually voided the vendor purchaser agreement because the conditions were not met. So that allowed the sale to go to White Spot. And let's have a look and see what the Court of Appeal found when this decision was appealed by the purchaser. So on appeal, in this case, the court was unanimous. This was in BC. And they were unanimous that the ROFRs were triggered. And in this case, they distinguished the facts from those in budget, which we talked about, which was sale of all the assets in several provinces. The Court of Appeal also found that White Spot was entitled to the segregated price. So that was confirmed, even though they hadn't asked for it. And by not providing a segregated price, the property owner was actually in breach of the ROFR provision because they didn't provide an allocation over the price. And importantly, in this case, though, the ROFR did not extend to the other property. So even though White Spot was able to buy both properties, only because the original agreement of purchase and sale was now void, they did so because of that and not because the ROFR extended to both properties. So that's it. So that's important. Next slide. There's another, so I'm going to do one more case and then I'm going to pass it over to Kim. So I found an example of a case that is more related to the mining industry that might be of interest to some of the people tuned in today. So this is also a case that's interesting if you have, whether you know it or not, any old royalty interest sitting around that might be buried in old agreements that some subsidiaries that you no longer need to keep around have. So in this case, the entity called Teddy Bear owned 2 mining royalties over properties that were owned by St. Andrew. And both the royalties were subject to a ROFR in favor of St. Andrew. But because Teddy Bear was going through difficult times, for whatever reasons, they decided to wind up the business. In connection with winding up the business, Teddy Bear transferred all of its assets, so a package sale of assets, to its largest shareholder and creditor, Canadex. And they did not provide notice to St. Andrew. They didn't say, hey, we're selling the asset, the royalty interest, which is our asset, and you have a ROFR over it. They didn't provide notice. So at the time when Teddy Bear's winding up was occurring, the royalties had no value and no one specifically turned their minds to them. They probably didn't know they existed, but for whatever reason, nobody I think dug through the documents to look at the provisions. So one day, the royalty actually became payable, and St. Andrew was trying to find Teddy Bear so that they could, make the royalty payments. And they learned that the transfer of the royalties to Canadex, the shareholder of Teddy Bear. So St. Andrew claimed that its ROFRs were violated when Teddy Bear failed to notify them of the winding up. So in this case, what do you think happened? Let's look at the trial judge's decision on the next slide. So in this case, the court found that the dissolution of Teddy Bear and the transfer of assets to Canada triggered the ROFRs. So that package sale did trigger the ROFRs. The ROFR provisions were broader than in budget. That was a bit of a distinction they made. And another key aspect that the court was looking at is whether a distribution of assets was effectively a transfer. So if you have a subsidiary or a company that's dissolving, like typically you do a conveyance of all the assets up to the shareholder or one of the shareholders, just to sort of leave no assets behind. And so the question was whether that distribution was actually a transfer that triggered the royalty, and the court found that it was. Now, this case was interesting, I think, because of the remedy. So the court found that the most practical remedy was simply to declare that the royalty obligations under the 2 royalty agreements were no longer enforceable against St. Andrew. So basically, Teddy Bear had this royalty, had this asset, but by breaching the ROFR provisions and not providing notice to St. Andrew, they actually lost all their benefits under those royalty agreements. So that's a bit of an interesting takeaway for any companies thinking they may have these old lingering royalty agreements around. And on that note, I think I'm passing it next slide and over to Kim.
Thanks, Nancy. So I'm going to speak about the Apex and Seco case. In this case, Apex and Seco entered into a joint venture agreement involving a multifamily residential project, which was called the Courtyards. And the JV had a ROFR in it. And the ROFR required that a party that was wishing to dispose of its interest in the JV without invoking a buy-sell provision, which was also in the JV, it had to first offer to the other party the right to purchase that interest on specific terms and conditions. And if the non-disposing party chose not to exercise its right, then the disposing party could offer the interest to a third party, but not on more favorable terms than those offered to the non-disposing party. And as I said, that JV also had a shotgun buy-sell agreement in it as well. So the relationship broke down, which is why we have litigation. And Apex disclosed to CECO that it was going to undergo a reorganization. And that would involve Apex transferring its interests in the courtyards to its parent company, after which Apex would then dissolve. And then the parent would then go through an amalgamation process, and its successor by way of amalgamation would then sell its interest in the courtyards to a new company. And it's part of this series of cases because Apex interest in the courtyards is only a small part of the total assets that were being transferred to the parent. Next slide, please. So Apex sought from CECO a waiver of the ROFR provision, and CECO didn't grant the waiver. And so Apex decided to go through the reorganization process anyway, which CECO wasn't made aware of. But a week after that reorg, CECO then triggered the shotgun provision and offered to buy Apex interest for $1.5 million. Apex accepted, but then CECO didn't get financing and so didn't go through with the transaction, and Apex sued CECO for breach of the shotgun provision, saying that it wasn't conditional on financing. You made this offer, so we've accepted the offer. You have to go through with that transaction. And in the course of that, CECO then found out about this reorg that it hadn't been told about, and it brought a counterclaim for breach of the ROFR provision. Next slide, please. So I'm going to focus on the counterclaim that was brought by CECO for breach of the ROFR. And so the questions that came up in the adjudication of the counterclaim is, was the transfer to a third party as a result of Apex's reorganization? The second question was the transfer upon dissolution a quote unquote sale, because there was a transfer and then there was a dissolution and all of that. And then the third question was this package question that we've been talking about in the other cases about whether the ROFR was triggered since the property was part of a package. Next slide, please. So the trial judge held and the Court of Appeal ultimately affirmed that a third party is any separate legal person. So it turned out here that the resulting Apex corporation had the same D's and O's, assets, liabilities, employees, management, and name. So Apex said, we're the same company. It's basically the same company. And the court said, no, you're not. Like, these are separate companies, notwithstanding all of those things. It's clear that this is a different company that now holds the asset. And so, yes, that met the third party criterion. The second question was there a sale? And Apex said, this wasn't a sale. This was a non-arm's length transfer to the parent, and it didn't engage the ROFR. And again, the court didn't accept that argument. It said, sale applies even in those, the commonly understood that a sale applies even in the context of that. And I'm going to quote from the Court of Appeals decision, which uses very colorful language. The Court of Appeal says, Apex's factum applies a freeze frame approach to its complicated corporate gymnastics, then suggests that at no one moment was there a corporate sale. However, for centuries, solicitors have tried to devise ways to evade legislation requiring taxation, registration, or government regulation. The usual strategy is to disassemble the regulated transaction into a series of individual small steps and hope that no one will look at the whole picture. There was no reason for this trial judge to ignore the overall scheme and final result, and properly he did not. I'm not impressed by Apex's argument that one step, a transfer from Apex to its new parent, was technically a distribution of capital on dissolution. That was mere subsidiary conveyancing mechanics. So, met the criterion that there was a sale. And then finally, there was this package question that we've been talking about. And so Apex relied on budget and said, look, this was part of a package of properties, and so it's not triggered. The ROFR is not triggered. And CECO, of course, said it doesn't matter that it's part of a package. If you look at the ROFR provision, on the terms of the ROFR provision, it's triggered. And the trial judge declined to follow budget and noted that the majority decision had not been widely accepted and relied and quoted on secondary source material that suggested that the reason why in budget the court said that it wasn't triggered is because it would be difficult for the court in that case, or in any case, to then try to figure out what the valuation of a particular part of the overall package, and that may have motivated the court in that case to say, no, the ROFR is not triggered. And so the court then held that the sale of a property that is subject of a ROFR as part of a package will, generally speaking, trigger the ROFR. And if that weren't the case, it would be basically rendering meaningless a ROFR if you could just include the asset as part of a package and therefore defeat the ROFR. And the Court of Appeal, again, in very colorful language, said that this argument that Apex had made that it wasn't triggered because it was part of a package, quote, makes no sense. And the Court of Appeal goes on to say, it would not only allow all the evils which a right of first refusal clause is designed to guard against, but introduce them in a more virulent form. One co-venturer could find itself not merely married to a stranger, but become a poor relative, even the junior member of a harem. So court's not impressed and says that the ROFR has been triggered. I'm going to pass it back to Nancy. Next slide, please.
Great, thanks, Kim. So the theme in those last few cases was really looking at this package sale concept. And so we have a couple slides here just where we want to take a moment to sort of reflect on what has sort of come out of those cases and what sort of tips can we provide to you to avoid some of the pitfalls or potential pitfalls that those cases were highlighting. So from the drafting perspective, so if you're setting out and you're negotiating your agreement that has a ROFR provision, these are some of the things that you can think about when you're drafting that provision. I don't want people to end up with like ROFRs that are pages and pages and pages long, but there are a lot of the little things that you can kind of add to make the agreement clear and the language clear. So one of the things to consider is is types of package sales. So when you're drafting your ROFR provision, should you contemplate that the sale of the property might be part of a package sale? And if you do you want to provide provisions that either protect against that or, at least provide guidance to the parties so they know what the rules are? So in this case, different types of package sales might be, sale of a business that we've seen, with budget, and it was a sale of basically the entire assets of a large company. Whether it's a dissolution and assets are just being pushed from a subsidiary up to a parent company, whether it's a merger, amalgamation, other types of package sales, you can think about them ahead of time and you can provide explicit language in the ROFR provision so that you can either exclude these or include these or sort of set the rules out for these types of potential third-party offers. So that's one drafting tip, is just to think when you're drafting the ROFR, do you want to provide for that sort of level of certainty or specificity? Another point is you may want to, when you do these package sales, and with the one example where we didn't have an allocation, a specific allocation for the purchase price, when you're drafting the ROFRs, you could think about adding a provision that says if the property is sold as part of a package sale, the property owner has to provide an allocation of the purchase price or a segregated purchase price to the ROFR holder so that they can make a decision on that specific asset. And then you're not getting into the issue, in the one case where, two properties had, one price, the $10 million price that applied to both properties. And it obviously caused a lot of confusion in that case. So you can add to your ROFR provision the requirement to allocate a purchase price to that asset, and that should hopefully provide more certainty to the parties. There's also considerations whether or not you exclude associated or related non-arm's length transactions. So when you're thinking about assigning an interest or selling a property to an affiliate, right? What does that mean? If it's assigned to an affiliate, should it be excluded from the ROFR? Should it trigger the ROFR? I think just sort of thinking through where that could lead from will sort of give you some ideas of what protections you want to put in the ROFR. And we're going to talk a little bit more about cases of where you transfer assets to an affiliate and where that can lead and what pitfalls you can fall in that path. Next slide, please. So those are tips I just talked about, that you can think about as you're drafting the provision. But what if you have a provision in front of you that you're now living with, and you are either the ROFR holder or the property holder, and you have to figure out how that provision works and how will the courts think about it. So just keeping on the theme of a package sale, you might think about the size of the package sale. So if you do have an offer from a third party and it's a package sale and your ROFR provision doesn't have any of those specific terms in it, you might think about how the ROFR might be treated, whether it's an automatic trigger or whether there's any ways that you see it not being triggered. So just to be thinking about that when you send the ROFR notice out, or if and when you send it out. Again, just the importance of allocating a purchase price to avoid problems when you're sending, the third party offer to the ROFR holder. Consider the implications if you do or you don't allocate a purchase price. Rights of holders to ask for a segregated price. So remember, if you're the ROFR holder and somebody sends you a package price, you actually have the right, according to the courts, to go back there and ask for a segregated price. So just keep that in mind. If you get the notice and you don't have a specific price for a specific asset, you can go back and ask. Again, consider what the implications of a dissolution of a property owner are. And this is important as we looked at that royalty case where they did a dissolution and they forgot to give notice under the ROFR, or if it's just simply assets being transferred up to a parent, that will likely be a trigger of a ROFR from what the cases show. And again, before winding up or dissolving, check for any agreements with ROFR obligations. I think it's just important to, when you're going through that exercise, to comb through any possible agreements you may have that have a hidden little royalty agreement tucked away in some of those old agreements. So those are our tips on the package sales. And the next question is, what if you or the potential purchaser intentionally overpriced the ROFR property to discourage its exercise? And I think we had a question from the audience about restrictions or pricing, well over market price. So this might answer your question, but we're going to get into the next few cases that will look at this concept. And I'm going to pass it back to Kim for this.
So I'm going to speak about a few cases that talk about how the duty of honors performance intersects with cases involving ROFRs. And so, taking a step back, obviously the court, the thing they focus on the most when they're trying to interpret these provisions is what do the words say? And they look at the words in the ROFR provision, and they look at the contract as a whole, and they try to interpret it. And so you should think of the duty of honest performance as something that applies in narrow circumstances where it's clear that one of the parties has done something untoward, but it shouldn't make you think that everything that we've just been talking about is now in a state of flux. It's really in exceptional circumstances that a party is going to be found to have breached this duty. Next slide, please. So I'm sure you've all heard of this case, the Supreme Court of Canada's case in Callow, which held that a contracting party must have appropriate regard to the legitimate contractual interests of their counterparty. And what does that mean? There have been a bunch of cases that have sort of tried to flesh this out. And something that is pertinent for the cases that follow is that this includes an obligation not to lie or knowingly mislead each other about matters that are directly linked to the performance of the contract. And the thing that makes people nervous, and rightfully so, is that this extends beyond outright lies. But in fact, if you fail to say something, in certain circumstances, that can be found to be a breach of this duty if you know that the other party is under the misapprehension of something, and it can be misleading not to correct a misapprehension. But needless to say, it's a very fact-sensitive exercise as to whether or not this duty is breached in a particular context. So this doesn't go so far as to say a party needs to subvert their own interests. It just means you can't lie or mislead, even by omission, in your performance of a contract. And this applies to all contracts. And it's not something that can be waived. Next slide, please. So one of the cases where this issue came up is a recent case of the Ontario Court of Appeal in Greta Energy. And in that case, Veresen, which subsequently became Pembina Pipeline, owned 3 wind farms, Grand Valley 1, Grand Valley 2, and St. Columban. And Veresen announced its intention to sell the wind farms en bloc in a bidding process. And so a purchaser came, Blue Earth, and said, I'll purchase them all. And the appellants in this case, Greta and GGVLP, held ROFRs on 2 of those properties. Blue Earth then submitted a successful bid and signed a PSA, and it required Blue Earth to submit an allocation of the purchase price to each property to comply with the ROFR notices. So the thing that got the appellants upset was that Blue Earth sent an initial allocation, but then revised the allocation between one of the properties and the St. Columban in the final allocation after it did some further analysis. And so the ROFR, and this was unbeknownst to the appellants at the time. So the ROFR notices were then sent, and Greta exercised its option to purchase under the Grand Valley 2. And so Greta then found out that there had been this reallocation of the purchase price after the transaction closed, and thought this reallocation had been done for nefarious reasons. And so it brought a claim against both Veresen and Blue Earth for breaching their duty of honest performance by manipulating the pricing of the assets to discourage the exercise of the ROFR. Well, that was their allegation in any event. Next slide, please. And they said that this was an exercise in bad faith, and that the reason they were doing this is to discourage Greta from exercising the ROFR, and that they knowingly misled them, to use the language from the duty of honest performance case law about the bona fide nature of the price allocation for the assets, and that was a breach of the duty of good faith. So both the plaintiff and the defendants brought motions for summary judgment. So there are motions going both ways. And the motion judge ultimately found in favor of Veresen and Blue Earth and said they acted in their self-interest and that there's nothing improper with them doing that. And then the plaintiffs appealed. Interestingly, the Ontario Petroleum Institute was granted intervention status in this appeal, and they asked the court specifically to provide some clarity on the duty of good faith and honest performance in a situation where a ROFR grantor agrees to sell a bundle of assets to a third-party buyer, where ROFRs are attached to some but not all of the bundled assets. So wanted some clarity from the court on this package concept, and the court said they didn't need to address those submissions in its reasons. So we don't know what the result was. It decided not to make findings in that regard. So we don't have sort of a final answer. In terms of the decision of the court, the motion judge held and the Court of Appeal confirmed that there was no issue with Veresen setting up a package bidding process where the price allocation was to be determined at a later point. The court said they did that. They got financial advice that selling these assets en bloc was likely to attract a better price, and there's nothing impermissible about doing that. The court also found that the reallocation was made for legitimate reasons. So as I said, this was the real thing that seems to have gotten the appellants upset. It wasn't that they were trying to defeat the ROFR as alleged, but the factual finding was that Blue Earth saw that there was a higher risk with the property without the ROFR because the sale required certain consents which could be withheld, and there was financing was a condition precedent. So again, it was allowed to act in its own self-interest. There was nothing impermissible about that. In the context of this litigation, part of the thing that Greta complained about was that there was an imbalance in information, and it didn't know why this reallocation had been done. And so it sought disclosure of all kinds of communication between Blue Earth and Veresen. And the court said that there was no duty to disclose that correspondence, but in any event, it had been provided and didn't affect the Greta's decision whether to exercise the ROFR. And this goes to the question that Nancy adverted to that one of our audience members raised about what is the relationship between the fair market value of a property and the exercise of a ROFR? Because one of the things Greta said was, this price allocation didn't bear the resemblance to what it considered to be the fair market value of the property, with an asterisk that it led no evidence as to what the fair market value of the property was. But the court said it doesn't really matter, that parties might value properties in different ways, and the fair market value of the property doesn't have any bearing on whether the ROFR is or is not exercised and whether or not there's been a breach of the duty of good faith. Next slide, please. So quickly, I'm not going to go through this case in detail in the interest of time, but I thought it would be important to distinguish the Gaddix case, which is distinguished in the Greta case. And basically in that case, the court found that there was a breach of the duty of good faith, even though it predated the cases that have found as a contractual term the duty of good faith, because in that case, they found that the reason the transaction was structured the way it was to avoid the ROFR. And you'll see there the quote at the bottom, it says that a party must not act in a fashion designed to eviscerate the very right which has been given. So that's the distinguishing feature between Greta and Gaddix, and you'll see in North Rock in a minute, that if you structure your transaction for the purpose of defeating a ROFR, you run the risk of having a court find you're not acting in accordance with the duty of good faith. But if you have other legitimate reasons for structuring your transaction that way, and it's consistent with the terms of the ROFR, then it's much less likely that a court is going to find that there's been a breach. Next slide, please. So this is a 2017 case of the Saskatchewan Court of Appeal called North Rock and Exxon. Exxon was interested in selling a group of assets, and North Rock had a ROFR on some of them. And importantly, in this case, and this goes back to what Nancy was talking about making sure that you turn your mind to whether or not you want there to be an exclusion for affiliate transactions. In this case, there was an exclusion for affiliate transfers. And Exxon did a busted butterfly transaction. So it transferred its assets to an affiliate, which again doesn't trigger the ROFR because that's an exclusion from the ROFR provision, and then sold the shares in the affiliate in a bidding process. And North Rock bid on that process, it lost, and then sued Exxon for breach of the ROFR and for breach of the duty of good faith. Next slide, please. So the questions were, did that transaction trigger the ROFR? And in either case, was there a breach of the duty of honest performance? Next slide, please. So again, the trial judge held in the Court of Appeal affirmed that the ROFR was not triggered and looked at the language of that provision and said, based on its express terms, a transfer of the interest to an affiliate didn't trigger the ROFR provision. So that was sort of the start and the end to that question. If North Rock had wanted the ROFR to be triggered in the circumstance where there was a transfer to an affiliate, it could have bargained for that right, and it didn't do so, or wasn't successful in doing so. And so the court says we're not going to read that term into an agreement that doesn't include that right. Next slide, please. And there was also a finding that Exxon did not breach its duty of honest performance. And so there was no finding of lying or misleading at any point in the transaction. And here there was evidence that the reason that it was structured that way was for tax reasons. And that there was evidence on the evidence in the case that was the rationale, which again can be distinguished from the Gaddix case, where there was very unhelpful evidence in that case, because all these cases turn on their facts, where the seller and the ultimate purchaser had these memos that they had written saying, we're trying to defeat the ROFR. How can we best defeat the ROFR? And so the evidence was really compelling in the Gaddix case that was why things had been structured this way. But both the North Rock case and the Greta case had evidence to the contrary that said, no, we did this for our own reasons that were legitimate, that were not for the purpose of trying to defeat the ROFR. And so the court then has a nice concluding sentence. Sorry, could we go back one slide, please? That says that, reaffirms what we know from the case law on a duty of good faith, that a breach of the duty of good faith may be established where a party is shown to have lied or misled, thereby breaching the duty of honest performance. Such a breach may be established where a party is shown to have structured a transaction for the purpose of avoiding a ROFR. So that really is the takeaway from these cases. Next slide, please. Over to Brian.
Thanks a lot, Kim. I'd like to talk about just one more situation or case, and this is another one drawn straight from the mining industry. And I think it's worth talking about, not because it stands for any particular principle of law, although it's consistent with a lot of the themes that we've heard so far, but because it's a great illustration of a creative and I'll venture to say unexpected use of a ROFR, as well as the kinds of tensions between junior miners and senior producers in a joint venture that we were discussing earlier in this. So it's kind of coming back full circle to illustrate a few themes. And we call this section using a ROFR to attack. So there are a lot of parties in this one, but it started with a joint venture between Xstrata Copper, now Glencore, and New Gold, who were partners in a project called El Moro, which was a gold and copper mine in Chile. As you know, consistent with the situation that we were talking about earlier in the presentation, New Gold was the relative junior of the two and had a minority interest of 30% in the El Moro project. Xstrata Copper was the major, and it had a 70% interest. And there was a joint venture agreement in the form of a shareholders agreement between Xstrata and New Gold. And in this case goes back a little bit. So in 2009, Xstrata was exploring a possible sale of its 70% interest in the El Moro asset, and it ran a value maximization process. It's also worth pointing out that the shareholders agreement between Xstrata and New Gold was governed by Chilean law, and of course, it contained a mutual ROFR. Next slide, please. So in the context of this auction, Barrick Gold was one of a number of parties that showed an interest, but Barrick made an offer to purchase Xstrata's interest for large purchase price, over $450 million. At the same time, Barrick was thinking to itself, well, we kind of like this whole project. So maybe we'll also make an offer to purchase New Gold's 30% interest. But the way they approached that was interesting, because if you did the math, the purchase price on a interest basis that they were offering to New Gold was approximately at a 1/3 discount to the value of the project that was the basis of Barrick's offer for Xstrata's 70%. And so New Gold, not surprisingly, was underwhelmed and rejected at first instance Barrick's offer for its 30% interest as a kind of a lowball offer. Undeterred, Barrick and Xstrata went ahead and entered into a definitive agreement later in the year for a purchase by Barrick of Xstrata's 70%. This, of course, though, was subject to New Gold's right to exercise its ROFR over the Xstrata 70% within a fairly lengthy period of 3 months. So coming back to themes we were talking about earlier, just go back to that slide for a minute. It sounds, when you refer to words like lowball, it sounds a lot like the situation we were talking about earlier in the presentation. You got a junior, it has a ROFR, it works in theory, but maybe not so well in practice, because there wasn't any way that New Gold was going to come up with more than $450 million to match the Barrick offer. So, and you also have to get the sense that by this point, New Gold was becoming a little concerned about what life might be like in a joint venture with Barrick, just, if nothing else, purely on the basis of the way Barrick had approached the pricing of its offers for the Xstrata interest and the New Gold interest. So what did New Gold do? Next slide. Well, the answer was it got creative. And the way in which it got creative is that it realized fairly early on that it wasn't limited to strictly marketing its own 30% interest, but it was interested in what the market thought of the various rights that it had in connection with the project. So it decided to run its own process in which it offered a range of outcomes to bidders as alternative ways to approach it. And one was a straight, a potential purchase of New Gold's own 30% in the process. But they also asked bidders to consider whether they'd be prepared to be involved in a transaction in which they would purchase Xstrata's 70% interest through the mechanism of New Gold's exercise of the ROFR. And this piqued the interest of a few potential bidders, including Goldcorp, which expressed interest in an arrangement whereby it would actually provide New Gold the funding for New Gold to exercise its ROFR over Xstrata's 70%. But then it would immediately purchase that 70% interest back from New Gold once the Xstrata interest was acquired by New Gold. Barrick was advised at one point by New Gold as a further negotiation that New Gold was considering this kind of a transaction in which a third party might exercise the ROFR or rather New Gold would exercise the ROFR, but with the financial assistance of another partner as a third party. And Barrick began, I think, to see that there was, some risk to what it was proposing. So it actually increased its bid for New Gold's 30% interest. And this time it went the other way and it offered a premium to even the implied value of the project that was inherent in its offer for Xstrata. So, at this point, Barrick was beginning to worry that it might lose the whole project just because of what New Gold was, contemplating with the partner. But New Gold, by this point, had crossed the Rubicon, and it opted to partner with Goldcorp instead. Next slide. So literally the day before the ROFR was going to expire, New Gold rejected the enhanced Barrick offer, and it entered into an agreement with Goldcorp. And it then immediately gave notice to Xstrata that it was exercising its ROFR to purchase the Xstrata interest in lieu of Barrick. The agreement between New Gold and Goldcorp provided for the structure of this transaction, and it was, in substance, fairly simple. Goldcorp made a loan to a subsidiary of New Gold for the ROFR exercise price. New Gold was going to use the funds to complete the ROFR exercise and acquire Xstrata's 70% interest, as it was entitled to do under the shareholders agreement. And then New Gold would turn around and sell that 70% interest to Goldcorp in exchange for the loan being canceled. And the result of this was that New Gold would become Goldcorp's junior partner in the mine in place of Xstrata and in lieu of Barrick. And this was attractive to New Gold for a number of reasons, both in terms of the relation, its sense of what the relationship with its senior partner would be going forward, and also because there was some cash on the table. New Gold actually got a $50 million cash payment from Goldcorp for playing this role in the transaction, as well as some softer benefits in terms of contractual provisions. Goldcorp was prepared to give New Gold a construction guarantee that it didn't have from Xstrata, and it wasn't expecting to be able to negotiate with Barrick. So this ended up looking like a pretty good deal for New Gold. And it was in fact completed pretty quickly, within about a month. Thanks. So yeah, so the transaction was completed. Now we can go to the next slide, please. Not surprisingly, Barrick was unimpressed with the way this turned out. And it challenged the exercise of the ROFR by New Gold. It sued virtually all the parties that were involved, including Xstrata, on the basis that Xstrata should have not permitted the exercise of the ROFR by New Gold because it was brought on flawed grounds. The thrust of what Barrick was arguing was that the result of this transaction was that New Gold had effectively sold its ROFR, being a contractual right under the shareholder agreement, to Goldcorp. Or if you look at it through another lens, New Gold had pre-sold the 70% interest that it was going to be acquiring from Xstrata before even acquiring it. And either way, under the transfer provisions of the shareholders agreement, which generally prohibited transfers except where they were permitted, and one of the reasons, or one of the mechanisms for a transfer to be permitted would have been if it went through the ROFR mechanism. That this was, an unlawful transfer under the shareholders agreement, and therefore Xstrata was in breach. What did the court think of this? Next slide, please. Well, the court, and again, remember, this was a shareholders agreement that was governed by Chilean law, although it was negotiated by Canadians with the assistance of Canadian counsel, and it looked an awful lot like a Canadian shareholders agreement. It was in fact governed by Chilean law for local reasons. The court said, nope, there was no breach by New Gold of the shareholders agreement, and neither was there a breach by Xstrata of its arrangement with Barrick, which was conditional on the ROFR not being exercised. The court in Ontario said that the ROFR was perfectly validly exercised by New Gold and through a creative mechanism, even though it had previously agreed to with Goldcorp to sell the 70% Xstrata interest if and when it acquired it. The court went on to say, just in the context of what the ROFR was intended to achieve, it said, look, the purpose of the ROFR was to allow each shareholder a means to avoid being in a position where it could be stuck with a partner that it felt was undesirable. This was a lawful mechanism that each of the parties had negotiated amongst themselves. And allowing a shareholder to borrow the exercise in order to exercise that ROFR, in the absence of a provision to the contrary in the text of the agreement, was consistent with this purpose. And so was allowing New Gold to contract that once it acquired the interest from the departing shareholder, which it incidentally had the effect of terminating the shareholders agreement between Xstrata and New Gold. At that point, Xstrata no longer had an interest in the project whatsoever. It had sold it. And so it should be able to do what it liked. And most importantly, and courts always fall back to what the language of the agreement says, none of this was prohibited. And there was nothing in the text of the agreement, of the shareholders agreement, to suggest that it was unlawful. So what does one take from all this at the end of the day? Like I said earlier, this isn't really a duty of honest performance case, although the conclusion is not inconsistent with those principles. And you've got to be a little bit careful applying it to other situations in Canada, since it turned on a Chilean law interpretation of the agreement. It's probably best served as a cautionary tale of what you can do within the bounds of the law with a little bit of creativity and by creating an opportunity. But in that vein, it represents a pretty interesting application of how ROFRs can, again, sometimes unexpectedly and creatively, be exercised by the parties. So with that, I'll turn it back to Nancy and Kim to introduce the next section on more tips and traps.
Okay, thanks, Brian. Can we just go back one slide, please? Okay, so I think we just have the last couple of slides in the presentation, and just wanted to think about the last few cases that we heard about and wrap up with a few sort of tips or different things to think about that has come out of the cases. So on the drafting side, so the drafting tip side, I guess one important note to make is that parties cannot contract out of the duty of honest performance. So that's important. That's a strict requirement. But there are some other drafting tips that you can take away. So I guess one thing is consider drafting to anticipate indirect transfers structured solely to defeat the royalty. So you may think about putting some creative language in the royalty provision that says, if there's a sale transaction put in place, solely for the purpose of or partially for the purpose of defeating the royalty, that won't be allowed. So you can kind of think about a little bit of creative language that might anticipate that kind of scenario and try to restrict it in the ROFR provision. Other provisions you might think about when we talked before about the importance of price allocations in the event of a package sale. Does the ROFR holder want to think about putting a reasonable requirement, like the price allocations have to be reasonable? Or can we sort of try to put any kind of control over how the parties might allocate it? Because it seems from the agreements that there is some room to, let's say, put a higher price allocation on some assets that are in a sale package. So if there's 5 assets and one has a ROFR, the parties might say, well, let's allocate more of the purchase price to this one asset that has a ROFR, because that might discourage the ROFR holder from exercising. So there is there's some play involved in doing these types of allocations from the court decisions. It shows, unless you do it solely to eviscerate the ROFR, and you put some ridiculous price on there that maybe isn't defendable. You can think about, to defend against that, if you're the ROFR holder, is putting in maybe some restrictions on how the prices are to be allocated. So that's something that you might consider drafting a royalty provision. And then the last point just goes to Brian's topic on El Moro. And if you're concerned about an El Moro like on sale, consider ways to prevent this. So consider what provisions you can put in the language of the ROFR provision to prohibit a prearranged on sale, maybe hold periods. So if you exercise the ROFR, you have to hold on to the asset for a certain period of time before you can sell that interest, or restrictions on third-party funding to help exercise the ROFR, without your consent. So you can build in a lot of creative provisions to try to protect against a lot of these sort of issues that we're seeing in some of these cases. Next slide, please. So again, the tips on this page is kind of considering you have an existing ROFR provision that you are dealing with. How do you perform it? In the notice that you provide, the information that you provide to the ROFR holder, etc. Remember that you can be creative in your approach. You may be able to take advantage of silence or gaps in the agreement, but don't lie or knowingly mislead, because that would breach the honor of the duty of honest performance. Another sort of tip you can think about, if a sales structure avoids the right to exercise the ROFR, consider the reasons for using the structure and carefully review the language in the ROFR. So again, this talks about Kim, where she had memos flying back and forth. We want to defeat the ROFR. We want to defeat the ROFR. How can we do that? Think about the reasons why you are structuring the transaction and see if they would likely be criticized. Also, if there is a package sale, consider the process for determining the allocation and the reasons for the allocation. Again, this is similar to the previous bullet, but are you making this allocation to just kind of discourage the exercise of the ROFR, or are you doing it to defeat the ROFR completely and avoid it, and whether that might be criticized or come under question? So careful determinations as you're deciding how you proceed with a ROFR provision if you are the property owner and you have a third-party offer. Also, evidence of intention to defeat a ROFR might be a breach of the duty of honest performance. So just keep in mind what the party's intentions are when they put, this structure in place to complete a sale. And I think that's the end of the formal presentation. I don't know if I want to pass it over to Kim, or if you wanted are we going to take some questions, see if we have questions?
Yeah, I think we will take some questions. I know there's a bit of a lag, so feel free to put your questions in the box. Just to elaborate on what Nancy was saying, and really the theme of this presentation as a whole is almost all of the work is going to be done by the contractual provision itself. And so you want to be very mindful about what the words of the provision say in the context of the agreement as a whole, and be mindful of the circumstances in which, notwithstanding what the specific words say, the court might find that there's been a breach. So the court, as a general matter of contractual interpretation, courts don't imply terms into contracts very readily. And so that's why you see in the package cases, the courts aren't going to say, well, just because this asset's part of a package, we're going to read into the contract something that says the ROFR is not triggered. They're not going to read that into the contract. And similarly, in these, honest performance cases, if the contract doesn't say thou shalt not transfer to an affiliate, the court's not going to read that language in there. So you really need to be very mindful of what the specific words are, and do some analysis about whether in a particular circumstance the ROFR is going to be triggered. And if your conclusion is this is permitted under the language, then just don't go about the business of creating a record that suggests you're doing it for nefarious reasons. And otherwise you should be okay. But it's all very dependent on the facts of the particular case. So I'm just looking to see if there are any questions.
There was a couple questions I noticed about whether ROFRs or ROFOs are registered in the land registry or title system. And I think it might depend on the type of document that the ROFR or ROFO is included in, whether it's actually registered, because often you'll see them as, a provision within a larger agreement. So I think that might depend on what type of agreement it is. If you're talking about in the mining context, where we see a lot of ROFRs in royalty agreements, the royalty agreement may be filed in the mining registry office, or if it's on a lease or real property, it may be, registered in the land titles office. So it might, I think, just depend on the type of agreement that the ROFR is actually included in for that one.
Yeah, I don't think it would be typical to file certainly a document like a shareholder agreement or a joint venture agreement on title if that were to contain the ROFR. And that's probably true even if the joint venture was, a joint venture was kind of on an asset as opposed to the company holding the asset. So it's entirely possible that ROFRs could not be in the public realm. Which, if you're entering into a transaction in relation to properties, that's, kind of a due diligence flag that you should be, looking at if you're considering acquiring an asset or even selling an asset that you maybe don't know the provenance of, and it's just in your portfolio.
Okay, so I want to thank all of you virtually for joining us today. Our next presentation is taking place in a few minutes at 4:00 and will be titled, They Come from the Land Down Under, Why Quebec is a Hotspot for Australian Mining Companies. And you can sign up for any of our upcoming webinars through the virtual calendar or by visiting the Fasken Institute section of fasken.com. So we hope you'll join us for our next session. Thanks very much, everyone.